Donald Trump has promised to launch a mass deportation plan on day one of his second term. Part of that plan may entail the use of the Alien Enemies Act, a wartime measure enacted in 1798 and last used in World War II to intern immigrants of Japanese, German, and Italian descent. Trump's inauguration is just a month away, raising some really big questions. Can he really use this law during peacetime to expel migrants? Who is at risk? And will the courts or Congress stop him? Well, there's some of the questions that we'll address today in today's Brennan Center event. I'm your moderator, Wilfred Codrington, Constitutional Law Professor at Cardozo School of Law and a Brennan Center Fellow. For folks joining us today, for the first time, the Brennan Center is a nonpartisan law and policy organization that works to repair, revitalize, and defend the systems of democracy and justice so they work for all in the nation. Brennan Center cannot support or oppose candidates for office, but it can and will offer the public vigorous debates on the policies and positions that matter for our democracy. Note that civility is important, and as such, anyone posting rude or inappropriate language in our message stream on YouTube will be removed from the conversation. Live closed captioning will also be provided, and you can follow along with the conversation on social media with the hashtag Brennan Center Live. So today we'll be joined by a panel of experts who will offer their insights into the history and the potential use and abuse of the Alien Enemies Act. So please welcome Catherine Jan Ebright, who is counsel in the Brennan Center's Liberty and National Security Program and the author of the great recent report on the Alien Enemies Act. Ilya Somin, a law professor at George Mason University, who has an expertise in constitutional law and migration rights. Karen Ebel, the president of the German-American Internee Coalition. Karen is a daughter of a former German-American internee, and she has written and spoken extensively about the World War II internment. And Rita Fernandez, the director of the Immigration Policy Project at Unidos USA, a Latino civil rights and advocacy organization. We are quite fortunate to have this group of experts here today. And so we're going to start our program, but just a quick reminder to the audience, please do ask questions, put them in the chat. We have saved time to address them at the end of the conversation. So Catherine, I'm gonna start with you. Why don't you just start out with some of the basics? You wrote this great report. What is the Alien Enemies Act, and what does the law intend to do?
Yeah, thanks, Wilfred. And it's great to be here raising awareness about this outdated and dangerous law. So I want to take everyone back to 1798 and an undeclared naval conflict with France known as the Quasi-War. So in that naval conflict, Congress had serious concerns about the longevity of our fledgling nation and about how to protect that nation. And it passed what became known as the Notorious Alien and Sedition Acts. Those were broad national security laws, and the general understanding, even at the time, was that the Alien and Sedition Acts went too far, that they impinged on civil liberties, and that they aggrandized presidential power in ways that were unsustainable. And because they were so controversial, even at the time, most, but not all, of the Alien and Sedition Acts were repealed or allowed to lapse shortly after their enactment. Of course, the exception is the Alien Enemies Act. And the Alien Enemies Act, unlike the other of the Alien and Sedition Acts, was not as controversial because it was the explicit wartime authority for if the quasi-war or some future war escalated. And so if that naval conflict ended up becoming a congressionally declared war, or if France decided that it wanted to perpetrate an invasion or predatory incursion against US territory, right? Because the quasi-war was a naval conflict, it didn't involve an attack on US territory, actually. And in those cases, a declared war or an invasion, a predatory incursion by a foreign nation or government against US territory, the president then could unlock the Alien Enemies Act's power. And that power that Congress decided to give it was substantial. Because the United States back in 1798 had virtually no criminal law and literally no immigration law, Congress decided that the president should have some sort of sweeping wartime authority, first to regulate non-citizens from a hostile foreign power or hostile belligerent, to detain those non-citizens, and then, if necessary, to deport them, all without a hearing. So without, what we typically think of as due process. And at the time, under the law of war, at the time, that actually wasn't problematic, because the law of war allowed nations in wartime to treat the non-citizens of a hostile foreign power actually as prisoners of war. The law of war said that these non-citizens had no rights whatsoever. And so the Alien Enemies Act covers these non-citizens based on their identity, not based on their conduct. And anyone born in or who holds the citizenship of that foreign hostile power can be targeted. Because again, the only thing that matters is the immigrant's identity. And, if that's the only thing that matters, you don't really need a hearing or other opportunity to prove that an individual is in fact law-abiding or loyal or not dangerous. And, we're going to get to this later in the program, I'm sure. But today, those intuitions that the founding generation had in 1798, given the law of war as it stood, given the status of our criminal and immigration law, those are no longer good assumptions. The law of war today and our own constitutional law look very, very different, where, you can't treat civilians like prisoners of war and they have rights. So that's sort of the lay of the land, the basic overview of what the Alien Enemies Act is and its context.
Thank you for that. That was very comprehensive, Captain. I'm going to go to you next, Ilya. You're a leading authority on the meaning of the word invasion in writings from the founding era, other works from the founding era, and a lot of the law hinges on that term. Can you maybe just tell us what the founding generation thought about that term, what it meant?
Sure.
What it applied
Let's
to?
step back for a moment and ask why the word invasion is crucial here. It's because the Alien Enemies Act says that the act only applies if there's a declared war between the U.S. and a foreign nation, which at this point there is no such declared war, or if there is an invasion or predatory incursion by a foreign nation or government. And some people on the political right argue that illegal migration can qualify as an invasion, or cross-border drug smuggling can qualify as such. If you look both at the original understanding of invasion in the 1780s and 90s, when this law was enacted, and also at sort of the common sense understanding of what this act is about, I think that simply isn't the case. That an invasion is, as James Madison put it, an operation of war, an organized armed attack. It's not merely illegal activity of some lesser kind, like illegal migration or drug smuggling or the like. This issue was debated in the founding era, not so much in response to the Alien Enemies Act, but rather because the Constitution actually mentions invasion in several places. For example, it states that states can engage in war if they're actually invaded, and they can do so even without federal government permission. The Constitution also says that the writ of habeas corpus can be suspended in the event of invasion, which means in plain English that the executive in that situation could hold and detain people, including even U.S. citizens, without charge and without a trial. And if you look at the founding era mentions of invasion at the Constitutional Convention and the ratifying conventions and other discussions at the time, it's pretty consistent that none of them say illegal migration counts as invasion or smuggling counts as invasion or the like. They all either refer to sort of metaphorical use of invasion, which are not related to immigration, like a metaphorical use such as invasion of rights, for example, or in discussing the actual invasion of provision of the Constitution, they pretty much all refer to actual military attacks. The Alien Enemies Act does also mention the possibility of a predatory incursion. There's, I think, less information with what that means. But again, that also would be some sort of an armed attack, not merely an illegal border crossing or illegal smuggling or the like. I would add also that the invasion or predatory incursion has to be by a foreign nation or government, and the current situation, nothing about it meets that requirement either. In that you certainly have illegal migration, you have drug smuggling, but it's not at the behest of a foreign government. It's not the government of Mexico or the government of some other country that's doing it. So I think the claim that the Alien Enemies Act can be invoked now falters, both because there is not an actual invasion or predatory incursion, and also because whatever is going on, it is not being orchestrated by a foreign government or nation and the like, and that also is a requirement of the act. If invasion could mean just illegal migration, it would have dire implications, not just for the use of the Alien Enemies Act, but also for things like suspending the writ of habeas corpus. One would assume that the use of invasion in the Constitution and its use just a few years later in the Alien Enemies Act have the same meaning. And if that's the case, then we could suspend a writ of habeas corpus pretty much anytime the government wants to, because we pretty much always in modern times have substantial illegal migration across the southern border, and also substantial drug smuggling ever since we've had a war on drugs. And one would think that if the founders had created a system where the writ of habeas corpus could be suspended at any time, they would have noted that, hey, like, you can do it anytime there's illegal smuggling, which, by the way, was something that was an issue during the early republic. And while there was not much in the way of federal immigration law at that time, there certainly were state immigration restrictions that some states, particularly on the Atlantic coast states, had. And so if any violation of those were considered to be an invasion, then states could engage in war anytime they wanted, and so on. So one would think that if invasion was understood this broadly, this would have been discussed during the founding, that would have been mentioned. He would have raised concerns about the writ of habeas corpus being suspended at any time, and that simply didn't happen. So I think that the argument that this is an invasion, is a bad argument. It should be rejected. And if courts were to accept it, if the Trump administration or any administration were to get away with this kind of broad interpretation, it would have pretty dire implications.
Yeah, so they actually meant invasion when they wrote the word invasion and nothing else. Right?
So
and probably an invasion of people, not like of bugs or something else too, right?
So one could imagine, an armed invasion of, military drones or something like that, or missiles. But I think we're talking about an organized armed attack as opposed to, illegal border crossing, drug smuggling, or any kind of smuggling and the like. Perhaps we will later discuss the issue of, there are some lower court decisions. Well, lower courts have consistently held, when they've defined invasion, that it is an armed attack rather than just illegal migration. Some of them have also said that the definition of invasion is a political question. The courts can't decide, even though at the same time they usually also said, oh, by the way, it's not illegal migration. So if courts were to hold that the definition of invasion is a political question and it's left up to the executive, then sadly the executive could potentially get away with this, though there still would be an issue of is it being done by a foreign nation or government, and that determination isn't necessarily a political question. Even if the determination of what an invasion is a political question. I myself think it should not be a political question. One of our other panelists, Catherine, has written very well on why it should not be so considered.
I do want to jump in on
Please go
just
ahead.
before we go down the political question rabbit hole too deeply. I want to circle back to something that I did raise, that there were these conversations about what the law of war allowed and didn't allow during the enactment of the Alien Enemies Act. And you may query, why would they care about the law of war if they're talking about all of these peacetime, non-military contexts? And I think that's just another piece of evidence that dovetails with what Ilya said, that this is not a peacetime immigration enforcement statute. It's not about a rhetorical invasion. It's about a literal armed attack.
But
that's
a great point.
Right.
And I would add, if I may, that at the same time as the Alien Enemies Act was enacted, the Alien Friends Act was enacted, the much more controversial and since allowed to expire and condemned as unconstitutional by people like James Madison. And the Alien Friends Act did, in fact, allow the president to detain and deport people, migrants and citizens of countries with which we were not at war. If the Alien Enemies Act was broad enough to allow the president to almost anything he wanted, one would think he wouldn't need the Alien Friends Act, and the Alien Friends Act would not have been so incredibly controversial. The Alien Enemies Act, by contrast, at the time was much less controversial, and I think one reason why is because it was assumed that it was limited to these situations of war and invasion, relatively narrowly defined.
Right. So we got this narrow definition of what invasion is. Predatory incursion, also narrow, whatever that means, and it must be against a state. I'm going to bring Karen into the conversation. Karen, you're someone with a parent who has experienced the world of internment camps. Maybe you can offer a little bit of a personal connection from the START chapter. Tell us a bit how this law was used in the past.
Yeah, sure. And thank you also for discussing this arcane and arbitrary law that I'm personally horrified that anyone would consider it using it in the way that it's being discussed. It had been around, obviously, for quite some time. It was used on a more limited basis to intern German men during World War I, but in World War II, it did come to, as you might say, full flower. The president issued 3 presidential proclamations following Pearl Harbor. They were identical. One applied to the Japanese, one applied to the Germans, and one applied to the Italians. And my personal experience and background has to do with the Germans, but what I'm going to say is mutually applicable to all of them. Once those presidential proclamations were issued, every alien, permanent or otherwise, who resided in the United States that was associated with those 3 countries was considered an enemy alien. And they had to register as enemy aliens. They were fingerprinted. Their travel was restricted. They had limitations on certain personal property rights. And at the time, you know, there were this land after the Native Americans, you know, we were based on immigration. And at the time, the census indicated that there were 600,000 Italians, 300,000 Germans, and approximately 100,000 Japanese. So when it was applied, there were 1 million people that were affected. So you can imagine the kind of upheaval that created within the communities throughout the United States just to have to do all the things that these now enemies had to do. The government also instituted what they called exclusionary zones. Mostly they were coastal zones. And if that sounds familiar to you, of course, the Alien Enemies Act was the seed of the eventual exclusion order 9066 that was applied to the full Japanese American citizen and alien population that lived on the West Coast at the time. But of course, the worst part of it was the fact that the presidential proclamations tracking the statute did allow the government to intern indefinitely or deport any enemy alien that it deemed potentially dangerous to the security of the United States. So at the time, the J. Edgar Hoover oversaw the FBI, and he had been very busy, probably anticipating eventually we would be getting to war, and they'd been very busy in various of these, the German, the Japanese, and the Italian areas. And when the proclamations were issued, they immediately did a sweep and arrested many, many people. There really wasn't the facilities to put all these people in, and so they were placed in jails, they were placed in hospitals. There were various detention centers that were established for various reasons that they were put in. But of course, the most ironic of all was Ellis Island, where many people were held. So the arrests, of course, weren't just in the beginning. They went throughout the war. There was a nod and a wink at the time to due process. There was a hearing that was conducted by the Department of Justice civilian hearing boards that were hastily created at the time. The folks that went before them, some of them were semi-fluent. They had absolutely no right to a counsel. They couldn't question the proceedings. For the most part, they never even knew that their hearing was coming up. And sometimes, of course, the hearings could take months before they occurred. Then they went back to their detention center, and the final determination was made in Washington. And if an internment order was issued, and frequently it was, they were sent off into this vast web of camps. And we can talk some more about my dad if you want, but there were many camps throughout the United States, including Ellis Island, all the way out to California, North Dakota, Texas. And there was really no notification to families where people were sent. And of course, the internees had no idea where they were going, and they had no idea how long they'd be there, and they had no idea how they would get out. So if you think about it just in the family context, fathers were arrested, mothers were arrested, fathers and mothers were arrested, children were left at home, people didn't know how they were going to live, and the turmoil in the communities was just really horrendous. That's pretty much a summary of the way it worked. Over time, the Department of Justice developed approximately, as far as we know, 50 different locations where people were sent. Eventually, there was a family camp created in Crystal City, Texas. You had to apply to go there to join your family member. Of course, not everybody could go. People were desperate. Some people agreed to be repatriated. Of course, other people were deported. There's a whole other area of the law where there were Latin American countries that participated in this, and thousands of Latin Americans were shipped up here, treated as illegals, and stuck into the camps. And this went on during the whole war. And even after the war, it was decided that, if you were bad enough to be in the camp in the first place, well, maybe you were bad enough to stay there. So as the camps were consolidated, many people eventually ended up in Ellis Island. It took congressional action to get them out. And the last person was finally released in 1948. That's a summary.
That is quite the summary. It's frightening and horrifying. And there's a lot in there that I actually want to come back to Catherine and Ilya to talk about. Before I do, that was 70, 80 years ago. And that's how it was impacting those communities. Rita, you direct the immigration program for one of the nation's leading civil rights organizations. If Trump does follow through with what he said he'll do and invoke the Enemy Aliens Act, how's that going to affect Latin communities today? And how's that going to affect your work?
Yeah, thank you, Wilfred. I want to start off just by saying that Latinos around the country are at a critical moment right now. Undocumented individuals, mixed status families where there could be a family member that is undocumented, and even US citizens of Latino descent face uncertainty given what could potentially come in the next administration. If the Alien Enemies Act is invoked for the purpose of carrying out mass deportations, it could allow the federal government to target and discriminate immigrants based on their country of birth. And this obviously has horrific consequences for Latino communities. But I'd like to make the point that I think sometimes is missed in conversations about this topic, that the Alien Enemies Act will have harmful impacts, not only for the Latino community specifically, but on all Americans more broadly. And the reason for that is that there are 62 million Latinos in the United States, making it the second largest ethnic group in the country. But I want to emphasize that regardless of immigration status or identity, the Alien Enemies Act affects all of us because there is no way to tell just by looking at someone if they are here legally or not. And so the federal government could, in that situation, be given the authority to essentially suspect anyone that might look or sound foreign. And these deportations, invoking the Alien Enemies Act for facilitating mass deportations, would have very harmful impacts on Latinos. The Latino community makes up the largest portion of all foreign-born people living in the United States. And Latinos also make up the majority of the undocumented population. We have approximately 11 million undocumented people living in the country, the majority of them originating from Latin American countries. And of the countries that have been mentioned as supposed perpetrators of an invasion, including Mexico, El Salvador, and Venezuela, they represent some of the top populations of the undocumented. So Mexico, for example, 48% of the undocumented, which is about 5.3 million, these are folks from Mexico. From El Salvador, it's 7%. And Venezuelans, there are 270,000 undocumented Venezuelans throughout the country. So mass deportations themselves will have irreparable harm on our communities. They can cause huge distress and trauma among mixed status families that might be separated as a result of a deportation. But as was previously covered, there are also instances where families will want to stay together, and you will have potentially a situation where US citizen-born children could also be deported. And of course, there are economic consequences. When a family loses an undocumented breadwinner, they could lose up to 47% of their income. And the Alien Enemies Act is so sweeping that non-citizens who are not necessarily undocumented but have other protections could also be caught up in these actions. So people, for example, that have green cards or temporary protected status, some of which come from Latin American countries like El Salvador, Honduras, Nicaragua, and Venezuela. And looking at the detention issue, there are already palpable fears about makeshift camps or staging grounds to hold people as they await to be deported. And this could really give the federal government wide-reaching powers to detain undocumented people and others for indefinite periods of time. We, of course, also have very serious concerns about potential civil rights violations in which Latino people or people of color more broadly could be targeted, questioned, or detained, again, based on their identity. And lastly, another concern is the absence of due process. People would likely not be put into standard deportation proceedings where at the end of the day, they get to go before an immigration judge. And, in the past, it looks like folks who were interned petitioned the courts for the writ of habeas corpus, but it looks like those were isolated incidents. Overall, this has very dire consequences for people's freedom and for their access to legal protections.
Thank you very much, Rita. And as I said, there are a lot of sort of points being raised here that have legal implications, and I'd love to get some perspective from you, Ilya, and Catherine. Ilya, first, this is meant to be a wartime authority. How is it even conceivable that Trump and his administration could justify it as, I guess, an immigration measure during peacetime?
Yeah. So I think we talked about this a little already. They're going to argue that for a very broad definition of invasion that encompasses illegal migration or the activities of drug cartels and the like, and therefore say there is an invasion or alternatively a predatory incursion. I've explained previously why I think that's not right. and why, if it were to be accepted, it would have very dangerous implications. But that is likely, what they plan to claim. And for all the reasons already mentioned by various panelists, if they were to be successful in that, it would both cause enormous harm potentially just with the use of the Alien Enemies Act, but also it would set a dangerous precedent in other respects, for example, for suspending the writ of habeas corpus.
And you said briefly before that some lower courts may have heard about this. What have lower courts said about this, and how might that impact?
So lower courts have said this not in the context of the Alien Enemies Act, but in the context of various provisions of the Constitution, which, among other things, give states the authority to do as much as engage in war in response to an invasion. This issue has been raised in recent litigation by the state of Texas, and courts have consistently rejected Texas's claim that there is an invasion. Also, there's another reference to invasion in the guarantee clause of the Constitution, which says that the federal government has to guarantee the states against invasion and protect them against it. And in various cases, some states have sued the federal government and said, well, the federal government isn't doing this because it's allowing illegal migration, or that too much of it occurs. And courts in those cases have also said that illegal migration is not an invasion, though, as I mentioned before, in some cases, they've more or less simultaneously said that the definition of invasion is a political question. So there's some tension between those two. To my knowledge, Catherine will correct me if I'm wrong, but to my knowledge, I do not think there has been any litigation on the meaning of invasion in the Alien Enemies Act specifically, but I do think it's reasonable and correct to say that the meaning of invasion is the same as between the Alien Enemies Act and the various constitutional provisions that I mentioned that were enacted only 10 years earlier. And obviously the discussions of the law of war in the context of the Alien Enemies Act and its enactment is an indication that those two things were supposed to be connected.
Yeah, I'll jump
and Catherine,
into.
you should, feel free to correct him if he's wrong. But I'm also going to just add a little bit more to you. You suggested that it's not just the authorities under the statute itself, but the statute itself may be the problem, right? It may raise its own constitutional and other legal claims. Can you talk about that?
Yeah, so the first thing that I want to say is piggybacking off of Ilya's point. The law has been used based on an invasion or threatened invasion or predatory incursion in one instance, and that was the attack on Pearl Harbor, which looks very different from migration. 2,400 Americans died. We just passed the 83rd anniversary of the attack on Pearl Harbor, which was, of course, a very serious armed attack. And so, to sort of create this false equivalence between the attack on Pearl Harbor and narcotics trafficking or, migrants fleeing persecution is a little ridiculous and frankly, a little offensive as well. But yeah, to jump into some of the challenges to the law itself, there are both statutory challenges and constitutional challenges. I'll try to keep it short here. But the challenges to the law based on intervening statutes is basically to say that there have been post-war developments in immigration law that displace or at minimum modify the deportation powers of the Alien Enemies Act. And, as I noted earlier, and as Rita and Karen have spoken to, the Alien Enemies Act historically didn't have procedural protections, and it also didn't have exceptions for people with status, including people seeking asylum. Actually, in World War II, as Karen well knows, there were German Jews who were even interned under this law. But in the post-war period, we ratified the 1967 Refugee Protocol, we ratified the Convention Against Torture, and we built out our immigration protections accordingly for asylum seekers and victims of torture. And there's a pretty good argument that those protections need to be read into any contempt or any law, including these older laws like the Alien Enemies Act. And there's a 2022 case from the DC Circuit called Huisha Huisha versus Mayorkas that supports reading the Convention Against Torture and Refugee Protocol protections into that kind of older law. And even if the post-war immigration law doesn't completely and totally displace the Alien Enemies Act, it still could make this a less attractive tool for the incoming administration insofar as there may be hearings, some process that's afforded to immigrants. And more importantly, or most importantly, it could prevent the repatriation of people who are fleeing persecution or torture to places where they would be harmed. There's also, of course, the whole constitutional suite of arguments, and that would be equal protection, due process, and separation of powers arguments. To run through those pretty quickly, the equal protection argument hinges on the Fifth Amendment and the right of individuals to be free from federal government discrimination based on protected traits. And Karen's talked about how immigrants in World War II were targeted based on their Japanese, German, and Italian heritage. That wasn't an accident. That was actually the design of the law. The law covers, quote unquote, natives of a hostile foreign power. So it's not just the citizens who have a legal relationship and formally owe allegiance to the foreign power. It's anyone who was born there. And since World War I, courts have recognized that nativity or birth heritage is an immutable trait. And in the post-war period, Congress and even George W. Bush's Department of Justice characterized that World War II use of the Alien Enemies Act as explicit ancestral discrimination. And the Supreme Court, more recently, has likened ancestral discrimination to impermissible racial discrimination. And that's, of course, bolstered by the fact that Congress paid reparations to Japanese internees under the Alien Enemies Act. It enacted a separate apology regime for the Italian-American internees. On the due process front, shifting gears a little bit, there are substantive and procedural protections that the Constitution may demand that the law include. So, you know, in our system of ordered liberty, it's not really appropriate or cognizable to lock people up or expel them based on their identity, as opposed to anything that they did. And we have a 2001 Supreme Court case called Zydvitas versus Davis that cast doubt on the kind of indefinite civil detentions that Karen mentioned that we saw in World War II, unless it's the case of an identified terrorist or highly dangerous suspect. There's reason to believe that other serious consequences, including expulsion or deportation, may also need to be based on a person's individual conduct that must be offensive or dangerous, as opposed to simply their identity. Now, if you go back to the World War II period in 1948, there was a Supreme Court case, Luedecke versus Watkins, that upheld the Alien Enemies Act against a due process challenge. But there were 4 dissenting justices who, in essence, made this kind of due process argument. And I'll read a little bit of language from one of those dissents, that it defied the American ethos to think that, quote, any unnaturalized person, good or bad, loyal or disloyal to this country, can be summarily interned and deported based on his citizenship or ancestry alone. And it's our hope that these dissents can be reframed as a majority view, not unlike how we have reframed the dissents in Korematsu versus United States, the case that upheld the internment of US citizens of Japanese descent. And once you start talking about, is this non-citizen who we're targeting actually dangerous? Have they done something wrong? Then that opens the door to some of these procedural protections that were absent in the World War II period, like appropriate notice, a real hearing, access to counsel, etc.
So we have these updated statutes enacted that we should be reading at least together with the law, and then a suite of constitutional challenges, equal protection, which of course applies to the federal government through reverse incorporation, as well as due process, substantive and procedural issues going on here.
Yeah.
I am told that we have a message from Senator Mazie Hirono. She has been working on thinking about this with her colleagues in Congress. So we're going to take a moment before the Q&A to listen to that message.
Aloha, I'm Senator Mazie Hirono. I'm glad to join you for today's discussion on the Alien Enemies Act and how we can combat the incoming administration's anti-immigrant agenda. The Alien Enemies Act is a xenophobic law from 1798. At dark times in our country's history, this law has been used to discriminate against certain groups. from the internment of Japanese Americans during World War II to Trump's Muslim ban in 2017. Now, Donald Trump is threatening to use this law to conduct mass deportations on day one of his administration. Trump's plan would be disastrous for our country and millions of immigrant families, and radically expand this hateful legislation. I'm proud to lead the Neighbors Not Enemies Act to repeal this outdated law and help ensure immigrants are treated fairly in our country. Today, the Senate Judiciary Committee had a hearing on Trump's dangerous plan for mass deportation, which could result in more than 3% of the entire U.S. population being deported. That's how many people are undocumented in our country. There are millions of mixed status families who will be separated. Chaos will ensue. As the only immigrant currently serving in the U.S. Senate, I'll keep working to ensure immigrant communities have the support they deserve, and I will keep fighting for long overdue comprehensive immigration reform. With a shared commitment to justice, we will continue advocating for the rights of immigrants and all Americans. Thank you for your commitment to this cause and to the Brennan Center for hosting this important and urgent conversation. Mahalo.
Again, that was Senator Mazie Hirono from Hawaii. And as I said, we're going to get to some audience Q&A. So I'll start out for anyone really here. First is, if Trump were to invoke the Alien Enemies Act, can Congress step in to prevent mass deportations and detentions?
I'm not sure if you're intending to start with me or with Catherine.
Well, either of you. I'll let
Okay.
you.
So in principle, Congress could do so. They could pass a law to repeal the Alien Enemies Act or to limit it. In practice, it would be very unlikely to happen, both because Republicans would have majorities in both houses of Congress, and also because even if Congress were to pass a bill, it would be subject to Trump's veto, which could then be overcome only with a 2/3 majority in both houses of Congress. So unfortunately, it seems to me at least very unlikely that Congress would actually do anything that that would be effective given the political situation.
Yeah,
So Congress has the power, but it is unlikely with a compliant Congress, the next coming Congress, that they would.
Or even if there was a majority that was willing to do something, so long as it was not a 2/3 majority in both houses,
Right.
probably the president would just be able to veto anything he didn't like.
Yeah, I do think that there are two potential vehicles that are must-pass vehicles through the Congress on an annual basis that you could try to attach repeal or reform to, and that would be appropriations and also the National Defense Authorization Act, which I don't think that this would be sort of out of the question, putting this into the NDAA, given that it is a wartime authority. And I know that there are senators, including Mazie Hirono, who sit on the Senate Armed Services Committee and on the House Armed Services Committee, who are actually pretty concerned about the Alien Enemies Act and the prospect for the military to, through this and other statutes, be at times involved in the mass deportation plan. And so, going back to the history, military bases were used for internment in World War I and World War II. The military was involved in transporting non-citizens to those internment camps in both of those wars. So again, I think it's possible, but to Ilya's point, pretty unlikely given the political realities.
I'm going to ask what seems like a natural follow-up from another audience member. What can state and local authorities do to protect their residents from deportation detention? And that's for anyone, again.
So states and localities can now, as in the past, they can choose not to assist the federal government. And indeed, during the first Trump administration, they actually want sanctuary jurisdictions won a bunch of cases on that issue against the administration. So given the limited nature of federal law enforcement personnel, that could constrain deportation and detention somewhat. Trump may well try to overcome this by trying to use the military for purposes of deportation. And that raises a whole set of other issues, both policy and legal.
I'll jump in with one thought on sanctuary cities. Not sure if Rita wants to add anything to this, but one thing that Trump has suggested he might do with the Alien Enemies Act is "quote unquote" end all sanctuary cities. Happy to get into it, but that is very far outside the scope of what this law can do. There are debates that were had in the Fifth Congress about whether this law should be used or capable, rather, of being used to target individuals who are harboring non-citizens under this law. And the lawmakers stripped it out because they thought that would give too much power in an already overcharged statutory regime to the president.
Rita, do you have something to add there?
Sure. I'll just add that, we're currently seeing many mayors and governors sort of double down on many of their sanctuary policies. And some states, such as California, have sort of very forward-thinking sanctuary policies. I think it's helpful to remember, though, in the first Trump administration, there were a lot of threats towards sanctuary jurisdictions based on funding. There were many restrictions that the administration was hoping to impose. So, if the Alien Enemies Act were invoked for mass deportations, I think it would be an open question as to how much leeway localities actually have, and states as well, especially given that this would be, supposedly a record-setting mass deportation plan, in historic levels. So it will remain to be seen, I think, how much mayors and governors, how far they can take that legally.
Another question from the audience, and maybe, Erin, you might have something to say here. Who could be affected by these? What types of people? Is it just going to be naturalized citizens, dual citizens, other categories of people? Do you have a sense of that?
Well, the government, especially in World War II, they tried to give it the broadest reach that it could. I mean, we've been talking about the undocumented, but they definitely were interested in permanent resident aliens, as they were called at the time. There were citizens that were also interned and deported because of the mixed family situation, the families, to the extent that they could, and honestly many times they couldn't, they could join their family members and then end up being deported. As far as naturalized citizens are concerned, there was also a pretty decent attempt by the government at the time to denaturalize people. In fact, that's what happened to my grandfather, who was also here. Fortunately, that didn't work. So in my opinion, unless you are associated with a family that is leaving and everybody is going together, I'm not sure that the Alien Enemies Act would permit the expulsion of actual citizens per se.
Yeah, but we should look forward to a very broad invocation, or at least purported invocation, in terms of who they're targeting.
Yeah, I would definitely think so. I mean, really, the effect on the mixed families was about as horrendous an effect as it could be, which a lot of people have already discussed. And it's very hard to know where the limit will be once they get going for anybody with these sorts of civil liberties violations.
And this is also a question from the audience. Maybe everyone can jump in about the impacts of the law. What are going to be the economic impacts, the sort of social impacts that this law could have if it's invoked?
Maybe if I could start off with that one. I appreciate this question. Sure. Thanks, Wilfred. So I appreciate this question because Unidos US actually just published a blog post on the economic impacts of deportations on the US economy more broadly. So I'll give you some of the broad strokes. I mean, I think it's good to keep in mind that the US workforce has 8.3 million undocumented workers. So that represents about 4.8% of all US workers. And many of these folks work in the agriculture industry. They actually account for 22% of agriculture jobs, 15% of all construction jobs, and 8% of all manufacturing jobs. And so if you consider taking 4.8% of our workforce away, right, there are serious fears that this will drive up the cost of food prices, the cost of housing, because housing or constructing housing will now be more costly. This will also, in the long term, impact our GDP. It could reduce our GDP by 2.6% if we were to reduce that percentage of our workforce. And there are also overall concerns about other US workers. There have been studies that have shown that in areas where there have been raids, sort of mass raids, workplace raids, that these raids have impacted the workforce in those local jurisdictions for both low-skilled and high-skilled workers. And so there are a number of overarching problems with deportations that could affect the economy, the overall workforce. So there are definitely, aside from the very humane impacts, there is a very solid economic argument that can be made.
I'll just add to it briefly. There was some analysis of the internment policy following World War II that just looked at the economics, and for what they thought that they gained in safety for the United States was far, far outweighed by the economic effects of, registering all these people, tracking them, interning them, and managing the whole situation. Because, in the end, ultimately people were released, but their houses, they lost their homes, their families were destroyed, they had trouble finding jobs, and the economic effects, never mind the humane and moral effects, just went on and on for a really long time. So ultimately, the cold-eyed view of it was that it wasn't really worthwhile.
Thank you. Another audience question, and I think this might be the last one, and I'll chime in after this, but someone wants to know, and I didn't think about this, but the connection between this statute and the immunity decision that has just been handed down last term from the Supreme Court that gives the president broad sweeping immunity. They want to know if that will have any impact on the ability to challenge this law in court, or I guess the redress ability, or anything that might be awarded in terms of if this were to succeed. Any implications between the immunity decision and this law?
So directly, no, in that all of the immunity decision has various flaws that have been documented by all sorts of people, but it only applies to immunity for the president for criminal prosecution. It doesn't block any civil remedies against the federal government, such as a ruling, for instance, that the use of the Alien Enemies Act in this context is illegal or unconstitutional or otherwise should be barred. So as a general legal matter, the immunity decision has little connection to this. You could argue that the president in the immigration area, as elsewhere, might be willing to take more legal risks in terms of his personal actions, hoping that he would get immunity in the future. But in terms of sort of direct legal remedies against the use of the Alien Enemies Act, the immunity decision has very little relevance.
Thank you for that. And we have a bunch of other questions. Some are very complicated, so I'm going to have to cut those off, but I am going to give one more question to everyone. Maybe they can respond in a few sentences in closing. Really, this has just been a fascinating conversation, a scary conversation, and I just want to know what you would like to leave audience members with this afternoon.
Yeah, thanks, Wilfred, and thanks to our audience. Internment was a shameful chapter of American history, and it's inextricably, centrally the history of this law. Instead of repeating the shameful mistakes of our past and reviving the Alien Enemies Act, whether in war or in peace, Congress needs to repeal this law. And Senator Hirono's Neighbors Not Enemies Act is a clean repeal bill. It deserves bipartisan public support. And if Congress cannot move that law or some sort of reform, the courts should absolutely strike it down or at minimum prevent an abuse.
Yeah, basically what she said, if this Alien Enemies Act is used for mass deportation and detention outside the context of a war or an actual invasion reasonably narrowly defined, it would cause enormous harm both to immigrants and also actually to American citizens as well. And it would set a very dangerous precedent that could be abused in other ways. Therefore, I hope if Congress does not repeal or limit the act, I hope courts would act against its use and would strike it down. If they do not, very bad consequences will follow.
I would say civil liberties are precious. My father grew up under Hitler. He left because of Hitler. He embraced freedom to the fullest extent. And it's very ironic when people leave situations like that they would be treated as the enemy because of their ethnicity. The Alien Enemies Act is arbitrary and inhumane, and it has no place in our democracy. It most certainly should not be used against immigrants, and it discriminates against our most basic human characteristic, where we were born and who we are. At its root, this law is utterly un-American, and it needs to be repealed and tossed into the dustbin of history where it belongs.
I agree with many of my fellow panelists, and I would add that invoking the Alien Enemies Act for the purpose of mass deportations is egregious, and would like to reiterate that invoking this act is not only harmful to Latino communities, but it is harmful to all of us. And I would also like to add to the audience, for anyone that is watching that feels emboldened to maybe take action after today's session, there are things you can do. There are organizations that you can donate to, that you can, volunteer your time to. There are organizations that are litigators, like the American Civil Liberties Union. There are organizations where you don't necessarily have to be an attorney to volunteer, or you can be an attorney with not necessarily an immigration specialization where you can volunteer. So there is certainly a lot of work being done on the ground, especially by organizations that help immigrants learn their rights and to represent them. And I would suggest looking to those organizations to pitch in.
Well, thank you for those closing words and for participating, Karen, Catherine, Ilya, Rita. It's been fantastic having you today. Thank you to the audience for attending and for your questions. I wish we could have gotten to them all. The Brennan Center does look forward to seeing you at future events, however, and to be the first to know about events when they're announced, be sure to sign up for the events newsletter at brennancenter.org/events. My name is Wilfred Codrington. I'm a constitutional law professor at Cardozo School of Law and a Brennan Fellow, and we thank you all for coming to this event.